Hey, government students. Today we're going to be talking about more civil liberties, and we've been so far talking about the freedom of speech, freedom of religion. Well, we also have freedoms in the area of criminal law, right? So from all the different parts of the process, that includes from the search and seizure of evidence and the arrest, through the questioning, through the trial, and all the way through the punishment. We call this these four steps, the criminal due process. And you have rights, stemming from the Bill of Rights and other parts of the Constitution as well, that regard the nature to which you can be obtained and also your rights as a citizen. So we're going to go through those now, and focus on a few court cases that help illustrate it as well. All right, so there are four stages of the due process, and they kind of go in order with the Bill of Rights. So usually regarding the gathering of evidence, we deal with the Fourth Amendment, which we're going to talk about first. And then as far as arrest and the pretrial, that also deals with the Fourth, but also the Fifth Amendment. The trial itself deals with the Sixth Amendment. And then finally, being punished for it deals with the Eighth Amendment. All right, so these are the four stages of due process. Let's start with number one, which is gathering evidence. All right, so the Fourth Amendment states that you have the ability to be secure in your persons, right? Meaning you should be able to have privacy, essentially, in both your person, like what's on you, your house, your documents, your belongings, from unreasonable searches and seizures, right? That's the key there. Unreasonable searches and seizures, like taking of evidence, and it shall not be violated by the federal government, right? We'll learn later that this is going to be extended to state governments, but originally it was only the federal governments. All right. And additionally, this also gives you the power of warrants, right? So warrants must be issued usually by a judge that needs probable cause. Okay, we're going to talk about that. Probable cause, as in like a valid reason as to why you would need to be searching this person. Like you see them running from a bank with a bag of money, right? That's probable cause to arrest and stop somebody, right? And so this warrant clause is important as well, right? So if those things are followed, then the justice system has the ability to search and seize you or evidence. Otherwise, they do not, and this protects you from that, right? So the question now is, what is reasonable is the first thing we're going to take a look at. All right, so the first scenario states that, and this is a hypothetical, of course, we like to do this, that Richland County Police received a tip that Macy Moran was engaged in illegal activity during the time that she was supposed to be working on student activities in 401. Acting on the tip, an officer went to Macy's home and knocking on the door, right? Knocked on the door. When Macy answered the door, she was holding a nasty coffee mug, the type of dirty dish that only could be stolen from room 401. The officer arrested Macy for theft on the spot and then proceeded to search the remaining rooms of her house for further proof of the crime. The search produced lots of additional evidence, including an overhead projector, some containers of paint, and lots of poster paper. But Macy contested that the search violated her Fourth Amendment rights. So was this reasonable? All right. So take a minute and kind of think, what is, what tells you in here that it's reasonable or unreasonable and it violated her Fourth Amendment rights? Right. This particular scenario would be considered reasonable, right? Because essentially, when she answered the door, it was in plain sight. They call this the plain sight doctrine for criminal investigation. So, like when the police knock on your door and they can easily see something that is illegal. So, in this case, a very clear, like stolen item. In this case, I mean, obviously, this is silly hypothetical, but this is an obvious coffee mug that was stolen, was reported stolen, right? All that kind of stuff. So, therefore, right, the cop has the ability then, right, once they know that a crime has occurred, they have probable cause to search the rest of the home. Okay. Now, additionally, all right, I shouldn't say the rest of the home. They are able to search anything else that is in plain sight. Now, if they proceeded to search the rest of the home that was not visible or in part of plain sight, then they would need to obtain a warrant first. Okay, so that's the only real difference there. So this is why you hear this come up with kids in college all the time. That's why they say the cop knocks on the door when they're having a party. Don't answer the door, right? Come back with a warrant, all that kind of stuff. Because if you open that door and the cops look in and can see illegal activity going on, they have the ability to have probable cause now to search that immediate part of the home. Okay. So that's where that comes from there. So it's probably a good thing to know in terms of your rights. But typically, otherwise, if you don't invite the cop into your home, you don't allow them to look in and all that kind of stuff, right? And ask them to get a warrant first. That would be your right, right, in that scenario. Okay. All right. So when conducting searches, right, there are different levels of warrantless searches. So cops don't always need a warrant, as you probably know, to make arrest or to search. Now, your home is considered a higher level, or a higher bar in order to get, typically they need warrants to search a home. However, cars, right, are actually more easily searched, and they don't necessarily need a warrant for searching a car. And the main justification for that is that cars are usually on public roads and are easily accessible. They are out in public, which is what the police is in charge of, the safety of the public, and therefore cars have a lower threshold. So as long as they have general probable cause, they can search your vehicle. Okay, and that's pretty wide discretion up to the officer. So they could say simply that they saw you not use your turn signal and were acting suspicious, and therefore they had that probable cause. That is left up to the officer. They could say that they smelled like alcohol or drugs coming from the vehicle. Those types of things lead to probable cause and allow the cop to search a car. Now, that same type of scenario where they smell illegal activity like drugs or whatever coming from a home, they are not allowed to search based on that simple probable cause. Okay. They would need a warrant on that because you are more secure in your home and your persons than you are on public roads with your car. Now, if that car is parked in your home, right, it would be treated the same as a home, if that makes any sense. Okay. So they do have different thresholds based on your private property that you're on versus public roads, if that makes sense. Okay. But typically warrants need to be issued by a judge in order to be searched. Now, what if they don't, the cop does not follow, these rules for searches and seizure? What can happen, right? This can be illustrated by the Mapp v. Ohio case, where a lady named Dorothy Mapp was, in her home when cops knocked on the door and asked to search their home for a suspected bombing suspect that they believed to be hiding out in her home. She said no, and after a while they got fed up and just searched her home anyway. And they didn't find the bombing suspect, but they found pornography, illegal pornography in her home. And Mapp did not plead not guilty to those charges of pornography. She said that pornography, though, was obtained illegally without a warrant, and therefore that should not be used against her in trial. And that is what they held. And this is upheld the what we call the exclusionary rule, meaning that evidence that is seized illegally, such as that pornography, because they did not have a warrant, they cannot use that evidence now in court. All right. So it doesn't mean that you can't go to trial for that crime. It just means they can't use that illegally obtained evidence in court. Okay. The goal there is to prevent, right, cops from violating the Fourth Amendment, right? Because if cops didn't have this rule, they might become abusive of their power and search homes and find evidence that they had no probable cause to search in the first place. Okay. So that's why this exclusionary rule exists. It's not to protect criminals. It's to protect people from being secure in their person and, under the Fourth Amendment, and also to prevent cops from abusing their power. All right, so let's test this in a couple scenarios. All right, the first one states, this is right. All right, the first one states, on a routine patrol, a cop noticed a suspicious-looking machine sitting on clear display in the window of Andrew Sullivan's residence. Without a warrant, the cop entered the home and found the device to be the same exact type of ice cream machine that had been reported stolen from Sonic the day prior. Andrew was arrested for possession of a stolen item. At trial, Andrew did not contest the charge that he had stolen the machine. He did argue that the machine could not be used as evidence at trial because the cop had violated his Fourth Amendment rights by not securing a search warrant before entering his home. All right, should this evidence under the exclusionary rule be admissible? The answer is actually yes, this evidence would be admissible. Okay, they have made exceptions to the exclusionary rule. All right, in this particular case, I've obviously changed some stuff around, but notice that the clearly stolen ice cream machine, this illegal item to be in his possession, was clearly on display from the road. So he's just driving by and can see illegal activity, and they allow the cops to be able to act on their own discretion. When they see illegal activity going on, they can act upon that without a warrant, right? Because if you have to wait on a warrant, sometimes the criminal is able to get rid of the evidence and not be able to be charged for the crime. This was based upon, obviously I changed stuff around, a real case where someone was growing marijuana in their window. Cop drives by and sees it, and anyway, they ruled this as an exclusion, an exception to the exclusionary rule. All right, here's another one. Let's see if this one makes sense. All right, an officer applied for a search warrant from a judge to conduct a search of Mr. Kelly's office on suspicion of violation of child labor laws. The judge granted the warrant, and upon conducting the search, the police found evidence that Mr. Kelly assigns way too many SCOTUS cases for students to read. The police arrested Mr. Kelly and put him in jail. But at trial, the judge found that the magistrate, or the original judge, had erred in issuing the search warrant for Mr. Kelly's office, as the officer had not sufficiently demonstrated probable cause. Mr. Kelly contests the search of his office now that violates his Fourth Amendment right. All right, so in this case, essentially, I get to trial and say that they never should have had a search warrant issued in the first place, and the judge agrees with me. However, the Supreme Court has ruled that regardless of the incompetence of the original judge, once that that search warrant is issued, it cannot be altered and it cannot be thrown out as a result. Okay, so it doesn't matter if the first judge made a mistake. Once that search warrant is issued, it gives that cop the free ability to search the residence or whatever the warrant prescribes. All right, so moving on to the arrest and pretrial action as well as the trial itself. All right, so the Fifth Amendment states that several different things, right? No person shall be held to answer for a crime unless the indictment by a grand jury, which we're not going to focus that as much in this particular instance. But one we are going to pay attention to, this clause of double jeopardy, right? You cannot be tried for the same crime twice, or the double jeopardy clause. Additionally, no one can be compelled to testify or serve as a witness against himself. So this is where we get the term pleading the fifth. You don't have to answer questions that might incriminate you. And additionally, that you are deserved the full due process of law before you are able to be imprisoned and taken away life, liberty, or property. Additionally, the Eighth Amendment comes into play here when you're arrested, because that's where excessive bail is prohibited, is in the Eighth Amendment. All right, here's another one. Actually, yeah, here we go. Reaching his breaking point from losing too many times at chess, Justin White simply ran out of patience, stole all of the chess sets in the Blythewood area, and then fled the state. Justin was promptly arrested and charged with violating state and federal laws. He contested the dual charges, claiming that they amounted to double jeopardy. Is that a violation of his Fifth Amendment right? And the simple answer is no, it is not double jeopardy. It does not violate his Fifth Amendment right. Double jeopardy applies to the same exact crime in the same exact court. If this was two charges, both in federal court for the same exact crime, yes, it would be. But notice this scenario talks about the same crime, but it violates both a state and federal law. So you can be tried in federal and state court, even if it's the same crime. And it does not violate the Fifth Amendment. So oftentimes when criminals are not able to be convicted in the state court, sometimes the federal court will charge them and go through a trial in an attempt to get a new verdict, all right, and ensure that the person is held accountable for their crime. All right, so Miranda versus Arizona. This is what we're going to talk about next in understanding that Fifth Amendment. All right, so the Fifth Amendment says that no one should be compelled to testify against himself. All right, Miranda versus Arizona, basically Ernesto Miranda was forced to answer questions without a lawyer present. He was not aware of his Fifth Amendment rights, that he didn't have to speak. And in that interrogation room, he was coerced into signing a written confession that he didn't write by officers. Right, and he did not realize that of the consequences of his actions. Right, and he felt this intense intimidation and pressure to do so. And essentially, Miranda sued the state of Arizona and under the Fifth Amendment, stating that he did not know of his Fifth Amendment rights, and therefore that confession should not be used as evidence against him in court. Right? He's not saying that he shouldn't go to court at all, but he's saying that confession should not have been used. Right? Because this creates a fear tactic, especially when people are unaware of their constitutional rights, and therefore they should in the future be made aware before entering into any type of interrogation or questioning. All right. So this is why we have today those Miranda rights, where when the cop arrests you, he says you have the right to remain silent. Anything you can say or anything you say can and will be used against you in a court of law, et cetera, et cetera. All right. Those Miranda rights, all right, come from this case because the court held that yes, people need to be made aware that they don't have to testify against themselves. And the general public may not necessarily know all their possible rights, so it's up to law enforcement to inform them of them. Right? If the law enforcement does not make them aware that they're able to have a lawyer present, and they don't have to, answer questions when asked that might incriminate them, then they have to throw out any of that evidence that were obtained prior to being Mirandized, is what they call it, or being read their rights. Okay. All right. So here is an example. Let's see if we can apply Miranda. All right. Tired of the higher standard that teacher kids are held to in an education system, Jordan Cribbs decided that she would hack into the Blythewood High database using Mrs. Cribbs' credentials and alter BHS students' permanent records to reflect her true genius and to show that she was indeed superior to all non-teacher kids. Since she used her mother's administrative credentials, nobody would ever suspect that sabotage, making herself valedictorian in the process. However, the cops were tipped off about her plans, and before Jordan could change the records, she was arrested. At the time of arrest, a police officer asked Jordan what she was attempting to do, and she confessed. However, at trial, Jordan contested that the computer used in the attempted hacking was not admissible because her confession was in response to a question asked prior to the reading of her Miranda rights. All right, so is that computer able to be used as evidence? The answer is yes. The computer itself can be used. However, her confession is not admissible. She would have to, the police officers in that instance would have to obtain an additional confession after she was Mirandized in order to gain it. But that computer is still admissible. It doesn't throw out all evidence, just that confession. Right, so it only applies to confessions or any other type of questioning prior to understanding her rights. All right, so moving along, going more towards the trial itself, we take a look at the Sixth Amendment. Do you have the right to a speedy and public trial? Yes, we see that there. All right, so you can't languish in prison, and it also has to be public, so people have to know what the goings-on were. You have the right to an impartial jury. Your right to be informed of the nature. So like you have to be informed why you're being, what you're being accused of. Anybody that was a witness, you must be able to test or must testify. So this is like why you get served with a summons. And if you are a witness to a crime or anything like that, then you have to testify. And additionally, you have the assistance of counsel, meaning you have the right to a lawyer. That's one of the big parts, right? So you have the right to assistance of counsel, a lawyer. All right, so understanding the Sixth Amendment, here's another scenario. A man named Clarence was arrested and convicted of breaking and entering into a bar with the intent to steal. He asked for a lawyer to be provided during the trial, but the judge informed Clarence that the state only has to provide lawyers to individuals charged with capital crimes, those involving the death penalty. Clarence appealed his conviction, claiming that his Sixth Amendment rights had been violated. This is a real case, right? So where Florida tried to deny Clarence Gideon his right to a lawyer and said that they would provide a lawyer for murder trials, but no other types of trials. Should the state of Florida have to provide a lawyer? The Supreme Court said yes. All crimes, criminal crimes, that is, like criminal court proceedings, are subject to having to provide a lawyer. So even states now have to provide lawyers for all crimes if they cannot afford one. Okay, so it will be appointed at public expense because they realize that everybody needs a lawyer in a criminal trial. They're essential to understanding the process and getting them through. All right, last one, the punishment stage. What protects you here? All right, the punishment stage is in the Eighth Amendment, right? So specifically no excessive bail or fines, but also no cruel or unusual punishments inflicted. All right, so here is our last thing that we're going to talk about here. All right, rules on the death penalty. All right, so is the death penalty constitutional? The answer is yes, the death penalty is constitutional, but it's left up to each state to decide whether or not their death penalty is constitutional. And you can see here in this map, the states in red have the death penalty and the ones in blue do not, right? But the Supreme Court has set limits on them, right? You can't have the death penalty for any charge. It has to be a capital crime, like those including like murder or terrorist attacks, things like that. And they also cannot be mandatory. You have to have a separate trial to determine not only if they're guilty of murder, but also whether or not they should receive the death penalty or not. All right, so they cannot be mandatory. Additionally, certain people cannot receive the death penalty, such as those that are mentally incapable of understanding their crime. Additionally, the minors, things like that, like people under the age of 18, unless in certain instances, cannot receive the death penalty. So additionally, they need a jury to decide this as well. It cannot be left up to a judge. It is left up for the jury to decide whether or not someone receives the death penalty. But for the most part, it is left up to each state what that looks like. Some still use, electric chair or electrocution. Some use lethal injection, and there's many other different types of ways that are still legal on the books according to each state. All right, so that is your due process of law. Remember, there's 4 stages. You have the gathering of evidence, right? Search and seizure, unreasonable, all that kind of stuff. That's the Fourth Amendment. You got your arrest, your Fifth Amendment, not having to testify against yourself. The trial, right to a lawyer, right? And then the punishment, the Eighth Amendment, cruel and unusual punishment.